Okay, people, it's 29 March and we're going to do revision on tort law today. Which court case? It was a common law case determined that obligations can occur in spite of a contract. In other words, even if there's no contract, you can still obtain certain obligations. And it all happened with a very important court case. And I told you to remember the name of that court case. So what is the name of that court case? And give in short the material facts of this court case as well. So please pause and do it first. And then the second thing that I want to ask you is, what is the privity principle? Pause and first answer it. Okay, people, that court case was, of course, Donahue versus Stevenson. And Stevenson manufactured ginger beer. So a rotten snail in Mrs. Donahue's ginger beer caused her to become sick and she got gastroenteritis. She sued Stevenson for compensation, but his defense was that there was no contract between them based on the privity principle. So do you now remember what the privity principle was? Okay, people, the privity of contract is a common law doctrine which provides that you cannot either enforce the benefit of or be liable for any obligation under a contract to which you are not a party. The underlying premise is that only parties to a contract can sue or be sued under it. In other words, if you and I make an agreement, your dad or your uncle or your best friend cannot sue me because that agreement was between you and me, and this is basically the principle of privity of contract. New Zealand has enacted the Contracts Privity Act in 1982, which enables third parties to sue if they are sufficiently identified as beneficiaries. Can you see why they brought in this new piece of legislation? In other words, if they are sufficiently identified as beneficiaries, then they can sue. Okay? And in the contract, it is expressed or implied that they should be able to enforce this benefit. Okay, so two things. Third parties are allowed to sue under the Contracts Privity Act in 1982, and if they are sufficiently identified as beneficiaries, that's the first point, and if in the contract it is expressed or implied that they should be able to enforce this benefit. Then I've got a question for you. What is negligence? Okay, people, on each slide you will basically see an answer to the previous to the questions on the previous slides, and you will also find a question for the slide that's going to follow. So yeah, the negligence, if we have to define it, it's simply conduct which does not meet this expected standard of care. So remember, we spoke about duty of care, and yeah, there's a certain expected standard of care. We expect a person to be as careful as the reasonable person in that situation would have behaved. Okay, so, and then judges will also look differently at torts and crimes in their judgments. Explain whether this is true or false and why. Why do you say so? People, the reason it is true, of course, but the reason why torts and crimes are treated differently is because crimes are supposed to be punished and torts are only aimed at compensation. That's why I've told you, in crimes, they will always, in criminal law, they will always find the person guilty or innocent, but in civil legislation, you are only liable or not. Okay, I want to give you a scenario. You took a ride on your bicycle past a house where people used to dig a ditch to lay a pipe earlier in the day. You saw them working there, digging that ditch, and they're busy laying a pipe. The ditch was now extended and included a portion of the pavement that was also dug away, but you did not see it when you came back, and before it was too late, of course. It's only then that you see it, and you fell in the hole, and your bicycle is badly broken. And the owner said that they have nothing to do with the incident. How can you prove that there was a breach of duty? People, that's simply the res ipsa loquitur principle, and according to which the mere occurrence of some types of accident is sufficient to imply negligence. I've also given you the example: you walk past a building and the next moment something is falling from the balcony of that building, and it's injuring you. Okay, people, so you can sue based on the principle of res ipsa loquitur. In other words, the mere occurrence of some type of accident is sufficient to imply negligence. So the accident wouldn't have happened unless somebody was careless and the defendant was in control. So explain the following terms. First, tell me what is a tort, and then tell me what is a tortfeasor. A tortfeasor. And with what issue or area of law does the law of tort keep itself busy? See if you can pause the recording and see if you can answer these questions. People, tort is a French word that means wrong, and it specifically means a civil wrong. So the person who commits the tort, we call him or her the tortfeasor. The law of tort deals with that branch of the law that deals with our civil obligation not to injure our neighbors. Why is the tort of negligence different from causing nuisance or defamation or trespass? In other words, there's different kinds of tort, and I've given you 3 examples: causing nuisance or defamation or trespass. But when we talk about negligent, we say there's something that makes it totally different from the rest of the torts, the rest of the civil wrongs that you can be responsible for. People, it's simply because all those mentioned torts are intentional, while negligence is happening non-intentional. In other words, you don't want to do something to damage your neighbor, cause him damages, but it's happening, and it's happening because you've been negligent. What are the basic principles or elements of the tort of negligence? In other words, I've told you there's certain principles, and I want to know what they are when we talk about the tort of negligence. People, those principles are simply that there's supposed to be a duty of care. How are you going to test to make sure whether a duty of care existed or not? You're going to look at those 3 elements that we've mentioned. Proximity, in other words, how near are they to you? Were they near enough? Or foreseeability, and whether it's fair and reasonable to say, okay, that a duty of care did exist in this situation. That's the first element that we have to prove. If we are able to prove that, then we can move, and only then, to the second element, because I've told you it's like different layers that we are building. It's like different layers that we build on top of one another. So if there's a duty of care, we have to prove that there was a breach of the duty of care, either negligent action or maybe a negligent misstatement happened. okay? But there was a breach of that duty of care. So if we can prove those two elements, then the next thing that we have to prove is that there was damage and it was caused by that breach of duty. Okay? Then, if I ask you when or how will a duty of care be established? Then, according to Caparo Industries versus Dickman, okay, people, I want to know what happened over there. Because in this court case, Caparo Industries Limited versus Dickman, how and when will a duty of care be established according to this court case? When and how will a duty of care be established? According to Caparo Industries versus Dickman. People, we already basically spoke about it so many times, but the first thing that you will look at is proximity. Over there, we're going to look at the closeness or the nearness to something. You have a legal duty towards someone close enough to be affected by your actions. It must be part of the group of people that you had in mind. In other words, they should be close enough. Not only physically, but also due to that relationship between the plaintiff and the defendant. Okay? So even if you're selling somebody to somebody else, and there's like a seller and a consumer or a producer-consumer kind of like a relationship, people, you were supposed as a producer to have like that consumer in mind. So even if it's that person is not physically near, because of that relationship, it can be close enough. So proximity, if there's proximity, then there will be a duty of care. Foreseeability, the ability to reasonably foresee or predict an outcome or consequence. It's important to decide if a person is liable. So foreseeability, that's one of the things, one of the tests that the courts will look at. And then the last thing, is it fair? And is it reasonable? Or is it fair and reasonable to basically establish this duty of care? Then I've got a question for you. What is the neighbor principle? And if you can answer that, I also want to know, what is the floodgate principle? People, Judge Atkin in the case of Donahue versus Stevenson said, we are all supposed to love our neighbors the way that we love ourselves. And if we are supposed to love our neighbors, it basically implies that we are not supposed to hurt them. So you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. What is the floodgate principle? Okay, the floodgates principle, or the floodgates argument, is a legal principle which is sometimes applied by judges to restrict or limit the right to make claims for damages because of a concern that if they permit or allow a certain claimant to recover in such a situation, it might open the metaphorical floodgates to large numbers of claims and lawsuits. In other words, you don't want every second person to claim for the same thing. Okay, another question that I want to ask you, what does injure mean in the light of torts? And what does damnum mean? People, injure in this context simply means to interfere with legal rights. Damnum, it's basically the original Latin for damage. What happened in Caparo Industries versus Dickman? Caparo Industries versus Dickman. People, in this court case, an accountant who was working for Dickman gave negligent advice and was sued by Caparo for damages because there was a company, Fidelity, that they wanted to take over, and as the Fidelity shares were worse than what the accountant made it out to be, or made them believe. In other words, the situation was even worse than what the accountant admitted. The accountant wanted to make it sound, it's not really a problem. Okay. Okay, people, what is a duty of care? And what happened in Hamilton versus Papakura District Council? And Grant versus Australian Knitting Mills. We did it last week, so I hope it's not boring you, but it's a little bit of important revision. Okay, people, what happened in Hamilton versus Papakura District Council? There was Hamilton planted cherry tomatoes under hydroponics, and eventually he died. And then he discovered that there was a certain element that caused this cherry tomatoes under hydroponic conditions to die. He then sued the council, but the council could basically prove that they've been filtering the waters and that they've done everything possible to make that water safe for human consumption. And because they've done everything to make it drinkable for human beings and without any negative effects, they've never concentrated on cherry tomatoes. Their aim was on cherry tomatoes, therefore they couldn't be kept accountable. Okay, so they were not negligent. In Grant versus Australian Knitting Mills, people, there was a severe case of dermatitis after this doctor wore underwear washed with chemicals. He took the company to court, and it was agreed that that company, when they washed that underwear with chemicals, they should have had like the consumer on the other side in mind. In Rolls-Royce New Zealand versus Carter Holt Harvey, 4 things that can be recognized by courts to determine negligence were listed. I want you to list all 4 of them. What balance did the court also refer to in its judgment? On proximity. They said, there's a certain balance that we have to keep into consideration when it comes to proximity. And what's a final determining test or factor in this court case? People, the court said in Rolls-Royce New Zealand versus Carter Holt Harvey that when you have to decide to consider stuff like this, negligence cases, there's basically 4 things that the courts will have to keep in mind. The first one is analogy with previous cases. And then they had to consider the vulnerability of people. In other words, those people, their need for law to ensure their protection. Because people are vulnerable, and some of these cooperative or corporate entities are very big and very powerful. So we need kind of like, as consumers, protection against them, because they've got all the financial abilities that we don't have. And number 3, remedies and other options available to the plaintiff. And then last one, the nature of the loss suffered. In other words, number 3 was their remedies. We've already seen what remedies was, the different solutions that they can apply in that specific situation. And then, of course, also the nature of the loss suffered. The plaintiff's moral claim to compensation for avoidable harm and the defendant's moral claim to be protected from undue restrictions on its freedom of action and from an undue burden of legal responsibility. People, that's basically the things that the court had to balance. In other words, if there's a contractor, we don't want to overload him with too much restrictions and legal burdens. We want to allow him to continue doing his business. He should not be responsible for every second thing. On the other hand, yeah, our consumers should be protected. And it's always difficult to do this weighing. What is weighing the most in this specific court case? Then I want to ask you something. Okay, in that case, I almost forgot that the crucial factor was foreseeability. The court also considered policy reasons. Now I want to ask you, do we owe a duty of care towards everybody, or is it limited? Okay, people, we already looked at that. We've done it several times, and yeah, even earlier in the slideshow, we've been talking about that. But a duty of care is limited to what is fair and just and reasonable. Fair, just and reasonable. People that are close enough to you to be affected by your action, people, they are your neighbors. And this is where the neighbor principle came from, that Judge Atkin formulated in Donahue versus Stevenson. What is a breach of duty? And how do you determine a breach of duty? Very important. People, to determine whether somebody was careless or failed to take reasonable care, we will always look at the reasonable person test. In other words, if we look at that required standard of care, if we want to test it, we will always apply the reasonable person test. In the past, it used to be the reasonable man test, but let's call it the reasonable person test. First question, what would a reasonable person have done in that situation? Then, once we've asked that question, and this is what reasonable people would have done, then we can ask the second question. But what did the defendant do? So this is what the reasonable person must do or should have done in a situation like that. And what did the defendant do? And if you haven't done what the reasonable person would have done, it will be a breach of duty of care. Okay, people, a person causing an accident is liable for all direct and indirect damages. Is it true or is it false? Explain this statement to me. Why do you say so? Motivate it to me. Now, people, of course it's false. In Maingard Packaging Limited versus Hilton Haulage, this is a court case, the defendant was liable for all damage which directly flew from his breach, and is of a kind which can reasonably be foreseen. So there were two legs in that test. First one, he should have been able to foresee it, and the damage should directly flow from that breach, not indirectly. Okay? Can one person be liable for damages that somebody else commit? Explain to me. What do you say? Yes, people, it is true. It's happening all the time where one people will commit tort, and a certain tort or the tort of negligence, but somebody else will be responsible for it, and we call that vicarious liability. Vicarious liability simply means to take the place of that person who committed the tort, and we often see it in that relationship between employer and employee, for example. And so if the employee is doing something wrong, committing a tort, if there was negligence on his side and damage were caused to a third party, that third party can sue the employer as if the employer himself did the wrong. When can an independent contractor be sued? An independent contractor. When can an independent contractor be sued? People, an independent contractor or a principal can be sued when that principal has also been negligent or contributed to the negligence in some way. Maybe that principal gave inadequate instructions and did not supervise the work done by that contractor. Remember, the principal has a duty imposed on him or her by law, and they are not supposed to delegate this to someone else. Especially when we look at the Health and Safety Act, people, and it's probably good to ask questions about that. When was the Health and Safety Act of 2015 reprinted? Who is responsible for all workers under this act, the Health and Safety Act? And where does this principle come from? Okay, people, liability under legislation, for example, under the Health and Safety at Work Act of 2015, makes a PCBU. What is the terminology PCBU? What does it mean? It means a person conducting a business or an undertaking, responsible for all the workers. Okay, people, in short, a business is profit driven, and an undertaking is usually they've got certain social aspirations that's driving them. A principal must take all the practical steps to ensure the health and safety of those people working for them. If an act prevents a person from excluding his legal responsibilities, then he will stay responsible. In other words, there's many situations where you cannot delegate your responsibility. You cannot contract out of the Health and Safety Act. If you are a principal, you are responsible for what's going on. A person conducting a business or undertaking, like for example, Northtec is a person conducting a business or undertaking, and they are responsible for the health and safety of the people on the Northtec premises. That's why they have to do adequate supervision and give adequate guidance, name it. Okay, but I've already told you, if people has, like, the more specialized the contractor is that's coming to work there, for example in electricity or IT or whatever, then you cannot really control the job. You know, you cannot really oversee it. So then that person, the more the person is specialized, the more he's responsible for his own safety. Give me two kinds of insurance that will be handy for you to have. Here we think about general public liability, and it's simply that insurance that covers damage to a third party, or products liability insurance. It's designed for businesses that manufacture and supply products. We are probably not going to be in that situation. Maybe you're going to work for a company like that. I've worked for Daimar Paints, where we made like products, and yeah, then you kind of like need product liability insurance. Professional indemnity insurance is a good insurance to have. It protects you against the costs of liability, the costs of defending a claim for the provision of incorrect or defective professional advice that you have given to a client. And then we can also have statutory liability insurance. It's cover for defense protection and fines for some breaches of legislation. And this is common in the building and construction industry. In other words, statutory liability insurance cover for your defense or protection against fines for breaches of legislation that you maybe accidentally committed. Okay, a policeman locks you up without a valid reason. you sue him for false imprisonment, what kind of damages will be rewarded in this case? What kind of damages do we have in mind? People, this is nominal damages. It's when you've been illegally arrested or a legal right of yours has been infringed. That nominal damages, it's basically nominal. Basically, you cannot decide about it. The court will have to decide about it. You phone your grandma in the USA, another scenario, and told her that you failed your exam. She got a heart attack there and then, and she fell over the table and the candle fell on the floor, causing the house to burn down. Are you responsible for this damage? Tell me, let's say you are. Is it true or false? And mention the kind of damage that the issue will be all about. People, that damages, that's too far removed. In other words, you couldn't have foreseen your grandmother getting a heart attack, falling over. It was not foreseeable. It's remote damages. It's remote. It's too remote. You will not be responsible for it. Okay. So the moment that it's too far removed and you're not going to be responsible for it, we talk about remote damages. What does volenti non fit injuria mean? And explain to me how it can prevent a person from claiming damages.